Good afternoon, folks, and welcome to our first module. Our lesson today is going to be on educational law and some of the cases that are landmark in the United States and specifically New Jersey that talk about different areas of student growth and what student rights have, teacher rights, and other areas. So let's get right into it. So we are here at New Teacher Orientation, right at Roxbury High School. We are going to be going over just a few cases that highlight the importance of past precedent set by not only the Supreme Court, but New Jersey District Courts, appeals courts, circuit courts. There's a lot of them. But basically the short of the fat is that these cases talk about what freedoms and rights students have, what freedoms and rights teachers have, how the school has to operate, things like IDEA, so it's disabilities, right, discrimination, student conduct, safety. So we're going to get into a little bit more of the nitty-gritty in just a second, but we'll be focusing on 6 key areas, and that is student rights, teachers' rights, school safety, discrimination and equitable actions, special education and disabilities, and student conduct and discipline. The cases we will be looking at is Morse v. Frederick, Garcetti v. Caballos, Verona School District v. Acton, Lau v. Nicholas, TR v. Kingwood Township, and Goss v. Lopez, and those are correlated with the topics above. So getting right into it, we have Morse v. Frederick. The background was a student was suspended for 10 days back in 2007 for a banner he put out that was "Bong Hits for Jesus." The principal suspended him under the drug and drug paraphernalia, but the student said it was actually his First Amendment rights to have freedom of speech. It went all the way to the Supreme Court, where the Supreme Court actually ruled in favor of Deborah Morris, who was the principal, and said, yes, the court, students have freedom of speech, but while they're in school, there are some stipulations. And this is due to the fact that it was drug-related, not just general political speech, but specifically drugs and drug paraphernalia and drug relations. So there is a time and place for freedom of speech. So Tinker versus Des Moines was slightly overturned here. Like that was a landmark case in 1969. It kind of set the rule, like I said earlier, that there were certain stipulations. So students could, for the most part, say what they wanted to, but when it came to things like drug or safety, you can't yell fight, you can't yell fire in a movie theater. It was under the same kind of channel. The next case we're going to talk about is Garcetti versus Caballos. And this was all about, it wasn't necessarily about teaching, but it could relate to teaching. We're going to talk about a case that kind of piggybacks off that in just a second. And this is the fact that a public employee, in this case a district attorney, criticized a case, an argument, kind of something the way that went down, and he was overturned for promotion. There was some back and forth, and it came out that the reason why he was passed up was because of his prior comments, and he said, you can't do that. Right, it's all part of the public domain. But actually, the Supreme Court said there should be some consequences for people talking about being in the public domain. And this corresponds where we circle back to education. It caps freedom in freedom of speech. So similar to the first case we looked at with Bong Hits for Jesus, this one caps it in regards to teachers. So there must be a cap. You can't say whatever you want to say about the public domain. If it does make shockwaves, there's going to be some kind of consequences. And it actually gets talked about a little bit more in 2014. The Ninth Circuit Court talks about Demers versus Austin, and that is faculty that criticizes university admins. If it's related to teaching or scholarships or events, they are allowed to do it if it's for the greater good. If it's just general and it's going to cause chaos and that kind of stuff, they are not allowed to do it. So there have been some cases regarding education, universities specifically, but nonetheless there is some kind of wiggle room. It's not just you say something bad and you get consequences. There is a little back and forth. So the next one is Vernonia School District. This one's pretty well known. This is about random drug tests and the Fourth Amendment for illegal search and seizure. Stems from a school in Oregon that assumed kids were under the influence of drugs, and they had random drug tests. They were actually concerned about athletes' health. And if a student failed the drug test, they were suspended. Now, it wasn't automatically, like, I see this person with marijuana or cocaine or whatever. It was just the assumption that they could do it. So it went all the way to the Supreme Court, which ruled in favor of the school 6-3, right? That drug tests, while students were in the presence of schools, right, there was a little bit difference than free adults, right? So this is, and we're going to talk about this in just a second, loco parentis, where students, while they're in school, while school officials are responsible for them, they don't have as much freedom as they would, let's say, in the regular world. So the school has to make the best call, the best judgment for what they see for the greater good. And like I mentioned earlier, right, there's a balance between how much freedom a student has versus how much they can do in and out of school. And this just goes to show that random drug tests are not, while in school, are not under the umbrella of illegal search and seizure. The next one we're going to talk about is Lau versus Nichols. That's 1974. This is all about ELL, and it began in 1971 when 1,800 students, Chinese students, did not receive ELL classes compared to 1,000 that did. It was brought all the way to the Supreme Court, and it was ruled unanimously that every single student must have the same educational rights. So they base it off the 1964 Civil Rights Act. It's also the notion of IDEA, right? And the fact that, or FAPE, right? That all of these things correlate, they're all aligned with the fact that every student must be given the same opportunities, whatever is best for them to learn. So these 1,800 students were barred from learning English compared to the 1,000 that weren't, right? And they must be given a fair shot. So next one we're going to have is TR versus Kingwood Township. This is regards to least restrictive environment. This was a student that was diagnosed as handicapped, and their parents thought that the school did not provide the least restrictive environment, so they sent their child to private school, where they thought the environment would be better. It goes all the way to the New Jersey Circuit Court, right, that deliberates over it, and the Circuit Court talks about how, yes, technically the school did provide an environment for the student that was very least restrictive, but they have to now take it case by case. All right, and also it made note that the school didn't have to change its entire program just for one student, but if other options, private schools, let's say for example a student is blind or deaf, the school has to send that student to that school, whatever is best for them, period. So if they don't have the program in the school at the time, they must make accommodations for that student. They had to pay the reimbursed fee to the private school. The school district is required to take into account a continuum of possible alternative placement options when formatting an IEP. So if the school does offer it, but another school does it better, they have to send that student to that better school. And then last but not least is Goss versus Lopez. This is all about student conduct and discipline. And this one focuses more on the 14th Amendment and due process. This is when 10 students from Ohio were suspended without any opportunity to address the issue. The Supreme Court was 5-4. The students were in the right, and they should have access to a fair system of due process. Right? So we talked about earlier student rights and freedoms when you're in school. This one is more, yes, students still have these rights of due process, of why were I in trouble, can I get a fair hearing, can I refute any of the evidence against me. This also applies to school conduct. Right? In the case was a landmark case that was awarded student an extension of rights and freedoms. The following, though, the debate was brought up that should this go too far in the fact that what happens if a student gets cut from sports teams or isn't allowed to join a club? Is there a due process in that? So where do we draw the line? That was kind of the counter argument in this Goss versus Lopez case. So we've looked at 6 cases, right, today, a very brief kind of crash course, but just know that educational law is one of the main driving forces, right? We may not see it every day, we might not be directly impacted by it, but it is a variable that is a constant in education. And it will continue to be a constant in education, and it will continue to evolve and grow as more cases and incidences and scenarios continue to build. And we, as educational leaders and teachers, need to be on top of this, right? We can't be experts. We can't know every law that's ever happened. But we need to be aware of some of the big ones, right? The driving forces behind it. And why they're important. And this is what that lesson today talked about. If you have any questions, comments, or concerns, right, you can shoot me an email or give me a call at any time, right? As noted, this is a continuing driving force, right? We need to stay vigilant, just like most updated technology lessons or better curriculum. We need to be involved with educational law as well. And just here are some references as we wrap up, and